All right, why don't we get started? I am John Haig. I am the co-director of the Mostafa Rahmani Center for Business and Government. It's great to see so many of you here, especially at the start of the semester. This is the first in a series of seminars that we're going to have over the spring around technology and regulation. We've been doing this now for a few years. We have a terrific group of people. This week we have a seminar today, which I'll talk about in a second. And then we have a seminar on Wednesday. We'll have another set in March and another set in April. And we have with us today the usual crowd. First of all, we have Gene Kimmelman, who is the person over there getting his drinks. And just a little bit of background on these people. And this is really the core of kind of what I consider our tech and regulation team. He was the Deputy Associate Attorney General at the Department of Justice from January 21 until August of 22, and he oversaw the antitrust and tax divisions, U.S. trustees program. He was also at one point president and CEO of a group called Public Knowledge, which is a DC think tank. And they focused on, that was for 6 years, and he focused on competition policy and advocacy, state and federal antitrust enforcement, and then legal scholarship in this general area of preserving competition. And he is currently both a senior fellow, research fellow here at the Center for Business and Government, but also a senior fellow at Yale University's Tobin Economic Policy Center, working with the group there. Second person we have is Tom Wheeler, and he is like broadly defined as everything, right? He is a businessman and author and former government official. He was chairman of the FCC from 2013 to 2017. He's a senior research fellow here, and he's also a visiting fellow at the Brookings Institution. For 4 decades, he's worked in telecommunications, and that covers a range of networks and types of services as this industry has merged. He was, when he was at the FCC, and we're going to have later sessions in March to cover some of these things in April, but he also oversaw at the FCC the development of the net neutrality rules. And so we're going to have a discussion on net neutrality and should it be resurrected or should it lay dormant in some form. I think Tom probably has a strong opinion about that, but I'll leave that for him to give you his perspective. And he is the only person, I find this interesting, he is the only person that is in both the Cable Television Hall of Fame and the Wireless Hall of Fame. And I don't know how many of you know who Bo Jackson is. Bo Jackson was this phenomenal athlete who played both football and baseball, and President Obama described Tom as the Bo Jackson of telecom. I'll do a little promotion for him. He has a book out called Techlash, Who Makes the Rules in the New Gilded Age, that I would encourage you to look at. But most importantly today in particular, we have with us Jon Sallet. And Jon is the general counsel of the FCC, or was the general counsel of the FCC working with Tom. He was Deputy Assistant Attorney General for Litigation in the Antitrust Division of the Department of Justice. He was Director of the Office of Policy and Strategic Planning for the U.S. Department of Commerce. He's got a number of publications out. I love the title of this one, Louis Brandeis, A Man for This Season, which is in the Colorado Technical Law Journal. He's got an article with Nancy Rose that just won some awards. This title, I'm still trying to figure out the title exactly myself, but The Dichotomous Treatment of Efficiencies in Horizontal Mergers. Too much, too little, getting it right. I think I know what that means, but I'm looking forward to being educated. And he is obviously a research fellow here at MRCGB, CBG. Now, if you'll notice, there's like an overlay or a current of lawyers here to talk about these issues. Although I don't think Tom's a lawyer, um, um, but but one of the things about competition policy, particularly in the United States, is that it is actually quite critical in the intersection between economics, the law, and a number of other disciplines that are quite critical in understanding how these issues are going to play out in the United States, which is why Jon is particularly critical at this point. Jon is currently, I think his official title is Special Assistant to the and General Counsel to the Attorney General of Colorado. And if you don't know, the Colorado is probably the lead state working with the federal government, bringing some of the antitrust lawsuits against Google. One reason I bring that up and that I want to emphasize is that today is off the record. Okay, today is off the record. And I want to just say that because Jon is thinking it and probably doesn't want to have to say it himself, but I'll save him having to do that. Today's title is Concentration, Competition, and Big Tech, Public Policy for the 2020s. The one on Wednesday will be a little bit more of a specific topic. It's antitrust and app stores, litigation, and international enforcement. Now, if you looked at the advertisement for today's session, it said that it's Jon Sallet and Nancy Rose. And Nancy, just so you know, is the Charles Kindleberger Professor, MIT Economics, and visiting scholar here at the center. And at some point, I feel like we should probably do a session on climate change because Nancy was out in California for a conference at the end of last week and over the weekend. And as you can imagine, given the weather in California, her flights have been canceled and she is on her way back, hopefully. But was supposed to get in yesterday, and obviously that did not happen. So that is why she's not here, but she has full faith in Jon to carry the load. Even if he's a lawyer and not an economist, he can discuss some of these issues. So with that, I'm going to hand it over to Jon, and thank you all for coming.
Thank you, Jon. Is this working okay? Just before I start on today's topic, I just wanted the word dichotomous. In the article that Nancy and I wrote, which did win an award, but I don't think just because of the use of that word in the title is going to be a topic we're going to take up in March. We're going to come back, as Jon said, for this set of discussions in March. And what we're going to talk about very specifically is mergers. Because today we're going to talk about big tech. But one key aspect of the way the economy works is merging. Good, bad, when, how do we tell? What are the rules? What are the rules like in the United States? What are they like in Europe? What are they like in the UK, for example? Nancy has studied this issue a lot. And so you may hear the title of that piece again during the March sessions. Let me just say I appreciate the chance to talk about these issues today. I'm obliged to say, because I do work for the Colorado Attorney General, that these are my personal views anyway. I don't make a representation as to whether they're interesting personal views or not, but you can decide that. And I want to talk about being a lawyer. I am a lawyer, and I'm going to talk about a lot which is not legal, economic principles. But my core purpose in presenting today is because I think, and I'll get to a slide that says this, the issues of competition in general and around big tech in particular are too important to be left to lawyers, too important to be left to lawyers and economists. They're very important issues of public policy. This is the public policy school. So all of you, I encourage you to engage with these issues as you think best, because one of the difficulties of public policy is if it gets confined to a specialty, lawyers, economists, technologists, and fails to reflect the goals and aspirations of society at large. I'm going to talk today a lot about Louis Brandeis, because that's a prism through which I view these issues. There's lots of different views that could be expressed on these issues, and I hope you'll hear contrary ones as we go along, either today or at other times. Here's what we're going to talk about, if we as time permits. I want to talk about competition and big tech, why the combination seems salient in today's world. I want to talk about some core economic principles, but I do want to we should keep in mind, I'm going to talk about economic principles that go back hundreds of years in some cases. We have a tendency to think that big tech is different than anything that's come before. Well, it may be in its final manifestation as a business model, right? But economic principles are not so limited. And the kinds of issues we're going to talk about, like network effects, vertical integration, one can find throughout the economy. Thirdly, as time permits, we're going to just touch on, just to give you a sense of the kinds of legal issues that are around the world in terms of big tech right now. And then just one slide offering some views about my own views about technology policy. So I'm going to try to keep going forward. You're a policymaker. I come to you and say, we're going to talk about big tech and competition. What would you want to know? I think you'd want to know some of these answers to this. What makes a firm or firms powerful enough to be able to harm competition? What are the circumstances in which the economics give firms the incentive, the desire to harm competition, not always acted upon? How do we tell whether what a firm's doing is harming competition? How do we tell what a firm could do that would promote competition? And if there is harm, what are we going to do about it? What's the remedy? If there's a potential benefit, can somebody pass a rule to get us those benefits? And of course, these questions are not limited to big tech. But for today's conversation, for what we're doing this semester, how do these questions apply to big tech? These are the kinds of things we'd like you to be thinking about. And so let's talk about big tech. Why is there so much interest in big tech? Well, we all use it every day, right? That's one thing. So it's very tangible to us. But some other points. It is ubiquitous. More than 5 billion internet users around the globe. And as of mid-January, the 6 biggest companies in the world by market cap were all tech firms. Apple, Microsoft, Alphabet, Amazon, NVIDIA, and Meta, Facebook. Big tech is controversial. A columnist for the New York Times wrote about big tech. Where there is power, there is suspicion. And there is suspicion, and there's concern. Is there too much monopoly power? Is too much personal data being collected? Is there too much false or hate speech that people spew using big tech, social media? Are there other horrible things like the child exploitation issues that were aired in front of the United States Senate last week? And of course, there's good stuff, right? I mean, is there anybody in the room today who isn't carrying a smartphone? Right, okay, so we're all using this all the time. And that means there's things we like about it. And we shouldn't ever lose that in a consideration of what we don't like. So let's talk about particular firms. If we get to the review of cases today, and if time permits, there are a set of these that in some way or another are being discussed as part of ongoing reviews. Google, Amazon, Apple, Meta, and Microsoft. So from among these firms, or any other tech firm, is there a firm that you think prevents customers, consumers from having better choices, or limits innovation by other firms, or prevents competitors from getting market share, limits the employment and opportunities available to workers, acquires companies that threaten to displace it? Anybody got a nominee? Any one of these? Tom,
All the above.
all of them. Okay. These are all competition issues. Somebody who's going to be smarter than that statement will tell me, no, some of these issues can be non-competition issues, and that's true. But each one of these can manifest itself through a competition issue. Which brings us to the question, what are we trying to achieve by competition policy? Right, in the US, we call competition law antitrust. But I'm using the term policy to mean not just what happens in court, but what happens in regulatory agencies, what happens in Congress, what happens in consideration of how to frame society. So two obvious questions from competition policy. What do we want to achieve? What are the outcomes that we think a competitive society can provide? And secondly, and this has become an important issue in the last few years, what do we think competition policy doesn't reach? right? We have, in the United States, food safety laws. Do we regard that as a competition issue? No, pretty much, right? Worker safety. Because the boundaries of competition policy are important. And then we're going to talk a little bit about what tools do we use to achieve whatever the goals are that we've determined on. Who's in charge of it? And very particularly, are we, I'm going to use the US a lot, but this is not only a US issue. Are we going to rely on just antitrust law or just sectoral regulation or both? Now, by sectoral regulation, I mean what Tom Wheeler did when what I was supposed to call him was boss, which was to run the Federal Communications Commission, a sectoral regulator, because there's a piece of the economy, telecom, media, TV stations, over which the FCC has jurisdiction. Could be energy, could be transportation, could be different railroads, different segments of an economy. These are sectoral regulators in the sense that they're not providing rules that every business has to follow, say a minimum wage. They're looking at something that's specific to something we think of as an industry or industries. And then, very important, even if we decide who's in charge, we got to figure out what makes them effective. If somebody's doing something wrong, and we think it's hurting people, what are we going to do to remedy that? This is a fundamental question that I think doesn't get enough emphasis, because all the rules in the world yield little result absent effective remedies. So in the United States, please, there's been quite a debate over the last few years about what it is that competition law is supposed to do. And I think it's a very good debate. And I want to give you a sense of how I classify the thinking. Somewhat idiosyncratically, I admit. Is the Chicago School. A lot of writing about the Chicago School. Established US mainstream view that focuses on what's called the consumer welfare standard, and we'll come to this, takes the fundamental view that monopoly power can be competed away, relatively simply. Not necessarily immediately, but it will be transient. Secondly, I want to talk about something that isn't really got the same legs, but actually is used a lot, which is the notion of protecting a competitive process. This is my view, I will just say, to be honest, about what antitrust law should do. And then I want to raise the question, very important, when do we want to use competition law antitrust to reach goals that go further? Income inequality, for example. So before we do that, I want to take a minute and see if I can get Louis Brandeis's picture to come up. He was a Boston lawyer. He was the original Brandeisian. I skipped it on the last slide, but I'm not going to use the phrase neo-Brandeisian. This is a phrase that's used a lot to describe new thinking in antitrust. I find it not specific enough to be helpful in distinguishing different views. But there was a Brandeisian, and this is the guy. He was a lawyer, a Supreme Court justice, an innovator in how we thought about the law. He fought the trusts, as they were called at the beginning of the 20th century, which is why we call the American law antitrust. And to me, he tells us a lot about how to apply antitrust principles and seek competition. I'm going to come back to it. But first, I want to go through the Chicago School. This is a very hard slide to follow. So let me try. This is a diagram that was published in 1968 by a very famous economist named Oliver Williamson. And he was trying to tell, actually, he started off by trying to tell his bosses at the Department of Justice what would happen if two firms merged and became a monopoly. And he meant, I think, like 100% market share, but had a monopoly. What would happen? And would it be good or bad for society? And I won't go through the pieces here, right? But what happens is there's a price, P1, then the firm merges and the price goes up to P2 and output, this is the demand curve. So demand goes down, but there's three outcomes, okay? firm profitably raises prices, and so some consumers, that's this triangle, stop buying the product. It's just too expensive. That's dead weight loss. They're out of the market. There are people down here, this is the firm, and they're the owners of the monopoly. And let's say there's cost savings. Their profits go up, right? Prices have gone up, prices have gone up, costs have gone down. The blue triangle is the extra profits they gain from having a monopoly. What Williamson said was, what Robert Bork later called consumer welfare, will come to him. Williamson used a different word. How we tell whether this merger is good or bad for people is whether this red triangle is bigger or smaller than the blue rectangle. In other words, whether the people who can't afford it anymore yield more or less in terms of, let's say, profits to the corporation, but whether this is a bigger area than what is good for the owners of the monopoly. There's a very important point here. If the owners of the monopoly make more money at the expense of people who can't afford it, and they make enough more money so that the blue triangle is bigger than red, that, Williamson says, is a good thing for society. Does that make sense? The owners of the monopoly, if they gain, they win. We don't hold this view right now, but it was fundamentally influential in saying how mergers ought to be viewed. But then there's one other piece here. There's this purple, this big piece. The biggest piece is this purple thing. That's the people who stick with the product and pay more. They're paying more than they used to because of the merger. Williamson says we don't pay any attention to this at all. Just irrelevant. We don't believe that anymore either, right? If a monopoly is going to raise prices, it's a problem. But this is fundamental because it kicks off a school of thought that yields at least 3 propositions. One, from the American lawyer, later judge, Robert Bork, in a book in 1978, the only legitimate goal of antitrust is the maximization of consumer welfare, and that means people who own monopolies. We have to worry about them. Secondly, from a very famous judge, because monopoly is self-destructive and monopoly prices eventually attract entry, over-enforcement is greater than the risk of under-enforcement. This is the most important principle, I think, that the Chicago School put up. It's not a good idea to enforce antitrust laws against monopoly. If monopoly is making that much money, everybody will come in and compete with them. They'll get competed away. So why are you wasting your time and maybe getting bad outcomes by attacking monopolies? Okay, this is a fundamental rule. And what it led to, the notion that plaintiffs think government enforcers have to carry a big burden. This has proven to be a very controversial approach. It's not the only one, though. And I want to give you a sense of what I think is more typical of what's actually happening in at least American courts today. There's a set of circumstances in which the famous Section 2 case, Section 2 of the Sherman Act against Microsoft, new merger guidelines that have been put out by the Federal Trade Commission and the Department of Justice, a recent action that the FTC brought against Amazon, all talk about the competitive process. Here's an example. What we're talking about now is not mergers. Can I just reset everybody on this, right? It's like a firm's just going along, it's got a monopoly, it's doing something. How do we tell if it hurts people? We don't ask about consumers, we ask about competition. So if a company, a monopoly, harms the ability of competitors to compete through conduct that benefits nobody except itself, one might think that's harm to competition. And I like this better because I think the consumer welfare notion was born of confusion and begets more confusion, because everything starts, you ask about who's the consumer, but I don't have to find, I don't think, an individual consumer. If a monopoly is strangling competition through conduct that we think has no pro-competitive benefits, then what the heck? The Microsoft court tells us that that's a violation of competition law. But even so, there's one more area that has been very important of late. People have been saying for the last few years, this whole antitrust thing, the problem is it's not expansive enough. You're forgetting about stuff that's bad in society and you're not doing anything about it. So I found this was a blog that was published in January by a student at Northeastern, which is not far on the other side of the Charles River. And I like this because I think it's very well put. The student says, the Chicago School's economic philosophy is disinterested in addressing inequality in any meaningful way. When firms are able to lower their prices, it doesn't mean that the least advantaged are always better off. And so it's better to think of antitrust policies through the lens of a justice conception in dealing with distributed justice, okay? You know, income inequality. Who's getting wages? How is that affected? How is money being distributed throughout the economy? So here's a law school hypothetical, but what the heck? Think of people who work as sellers. They're selling labor, right? And employers are buying. They're buying the labor. So here's two hypotheticals. Two manufacturing plants in a small city merge, and the manufacturing workers, right, the people working in both factories, lose the ability to try to play one off against the other, okay? So the merged companies, there's no competition for these workers. It's a small, let's say, geographically insular place. They cut wages. That's the first example. The second is, same two plants, same small city, they're each running at 40% capacity, right? They've got an assembly line or something. It looks like an old Charlie Chaplin movie, an old reference even for me. And so they merge and the factory is more efficient and they save money, and some of it is passed along to people, but they need fewer workers, okay? Anybody think either of these should be illegal? No? You don't think so? Anybody think? Okay, here's the way it works. Right now, there's a new push, and I think this is the right thing to do, in antitrust to think that's a problem, the first one, because it's a merger to monopoly of the purchase of labor. And monopoly power used to gain a commercial advantage through a merger, I think is not a good thing. The second one, much harder to know under current law. But what is happening, and this is a good thing, and we know this because Dean Kimmelman was responsible for bringing a fundamental case that the Department of Justice won, is that when you're buying labor or buying the fruits of labor, let's say books, if you are a buyer, not a seller, you can nonetheless violate the antitrust laws if you engage in the same kind of conduct that would make a seller be illegal, being the only game in town through some conduct that's bad or through a merger. So this is the sort of stuff of which antitrust discussions are made. But let me talk about now who does it. We have to decide. So you guys can all decide, do you like the Chicago school? You don't like the Chicago school? I feel obliged to say there was also a Harvard school. There's my view of antitrust. People can agree with or not. There's views that it ought to be more expansive. But who's going to make the decision? Should it be a legislature? Should it be a judge? Should it be a specialist regulator? The Federal Trade Commission was created because Brandeis particularly thought it'd be good to have experts someplace who could review issues. Should it be sectoral regulators? So Tom and Jean, and perhaps they will talk about it this semester, Tom and Jean wrote a very influential paper with a colleague a few years ago proposing what a digital agency would look like to regulate the big tech firms. Should we look to that? And then how do we make it work? So let me just take a second and go through some of the choices here. I am an antitrust lawyer. So it's not a very surprising view that I think there is some role for antitrust law in dealing with these issues. And some of the advantages that Brandeis saw that strike me as helpful is you get an approach that's not industry specific. You try to be consistent across industries. You go deeply into the factual record. And because you're a generalist, because judges don't see that many antitrust cases, but will decide very important ones. Any single judge doesn't see, does not capture political capture of a regulator. That's the theory. But increasingly, people began to have questioned if antitrust is enough. This is a very famous cartoon from about, I don't know, 1900. This was the trust busting era. This octopus with an oil tank on its head or forehead is Standard Oil, you can see. And the octopus is because Standard Oil controlled so many different things in the economy. So antitrust, it is said, is case by case. You take one case at a time. It can take a long time. It has to do with specific, not all firms. And so people ask, is it too complicated? Is it too slow? Is it too narrow? The worker issue. Is it too generalist? Not enough expertise. And this is what has led to the suggestion of sectoral regulation. I'm not going to do justice to Tom and Jean's notion and specific proposals, but in a typical way, a regulator looks to the future, not just to the past, which is what antitrust does, and can put out industry-wide rules, not just individual cases. So when Tom, when he talks this semester about the net neutrality rule, that was a rule that was going to apply to all the relevant firms. It doesn't require that people who've done stuff in the past, if we want them to do better stuff in the future. You don't have to litigate past conduct. And we'll see how much deference it gets. Regulatory expertise can be important. So we have very important examples of sectoral regulation around big tech. And let me just mention too, there are other important activities going on, but just to note, in Europe, the Digital Markets Act. People familiar with this? Okay. So the Digital Markets Act really is breaking new ground. It's a European law that regulates what it calls gatekeepers, which are really sort of big tech firms buy particular forms of business activity. And those designations have been made, some are on appeal. And as of next month, and Jean's going to talk about this in April, as of next month, we will have the first reports out of how companies are complying with the Digital Markets Act. It is a big effort to constrain digital firms, big tech, from limiting the ability of others to compete with them. It applies specific prohibitions. Side loading, people know side loading from the app stores, right? If you use Google or you use Apple, well, Apple, very particularly, there's no opportunity to have a different app store on an Apple phone. On Google, there is some, but it's viewed as limited. That's dealt with. If you have a text message, if you don't like the fact that your text message service can't connect to people using a different text message, that's another issue that's dealt with. And there are a lot more. At the meantime, the United Kingdom is considering the Digital Markets Competition and Consumers Bill. The UK puts a lot of emphasis on consensus. So now we're back to the business of how to get things done. The DMA is a series of, generally, one could describe prohibitions. The UK Act, which people think will come into law this calendar year, according to the UK government, seeks to resolve concerns through informal and cooperative engagement with firms. This is a big decision, right? To what extent can you work things out with firms? The UK has taken this approach. If the law is enacted, it'll be very interesting in years to come to see how it applies and compares to the DMA. So I said earlier that we can make all the rules or win all the court cases we want, but like what then happens? And this is the question of enforcement and remedies. And there's one issue that keeps coming up. Should a company be broken up, right? Should it be divided into component pieces? The most famous a very famous example in US history was the breakup of AT&T in the 1980s, right? AT&T, the monopoly, private, but monopoly telephone company, divided into different pieces, the Bell system, long distance companies. I think generally viewed as a success. So some people, scholars, are arguing that big tech firms should be broken up into small pieces. This would be a very contentious question because under US law, there's quite a bit of debate about when divestiture is appropriate. Okay, anybody got a view about this one? Anyone got a tech firm they want to see broken up? Or the other way, don't want to see broken up? Okay, this is one for you to think about as well. I want to take a few minutes to talk about some basic economic principles that also inform these. And these are some conclusions that Jason Furman from here down the hall, next to John, authored as part of the Furman Report, which was the United Kingdom's view of what to do with the digital economy. And he came about his report, which included other very eminent experts, came out with a series of notions of what could happen in a digital market. But what's important is, I think, that the report thinks that opportunities for competition are less than we might expect, that entrenched market power in a digital market is harder to displace and is harder now than it used to be. Networks effect and returns to scale of data appear to be more entrenched, the report says. So this tells us something, right? A few minutes ago, I was saying the Chicago School says monopolies basically dissipate. This is a review of in digital markets to suggest not so likely to happen. And part of that comes out of what a digital platform looks like. So here's this it's not true for every digital platform, but here are some characteristics I want to just review because I think as you guys think about these issues, they're important. Network effects, a multi-sided platform, market power, and vertical integration. Not, by the way, in that order, because I went the wrong way around the circle, but it'll be okay. This is a newspaper ad, I guess, magazine ad from the 1950s by the Bell telephone system in the United States. You're never alone with a telephone. Somebody made that up, really. I mean, like it rhymes and everything. If they were selling a book, you wouldn't say this, right? A lot of people say, I'd like to be alone with a book, right? That's something I can do by myself. I want to. I like the peace and the quiet, but not a telephone. A telephone has no value except as a paperweight if you can't talk to somebody else. This is a direct network effect. The value, this is Metcalfe's law, of having a telephone gets increasingly high the more people there are you can talk to, okay? But there's something called an indirect network effect that has more saliency in this context. This is a newspaper, like an old newspaper, like when they were on paper, okay? Advertising supported. Everybody knows about these. Advertisers buy space in newspapers to reach readers. That's a multi-sided market. Why? Because if you're the newspaper, your job is to bring these people together in a way that makes you money. And one of the ways you have to decide that is you're going to charge advertisers how much, and you're going to decide whether you charge readers at all, and if so, how much. And you want to be careful, because if you charge advertisers too much, they won't show up. If you charge readers too much, what happens? They don't show up, and then you don't get advertisers, because the advertisers are only there because you're attracting the readers. This is the essence of a multi-sided platform. Tech firms tend to be multi-sided. Well, an advertising-supported business is by definition multi-sided, right? But you can have other forms. So multi-sided, right? Direct network effects. I have a telephone. It works better if you have one too, right? Indirect. I'd like to advertise. It works better if you see my ad. And even better, the more I know about you. This is the concerns that some people raise about personal data. It's used. Multi-sided models. You're a platform. You say, advertisers, here are consumers. Consumers, I hope you enjoy the content. Hope everybody gets along. That's the model. A successful multi-sided platform, to the extent it gets better and better as a result of more and more users and more valuable to advertisers, will be realizing scale effects. And that can make it hard to compete, right? If you want to start a business against a company that's got a lot of users and advertisers, you've got to figure out how to get enough users to get enough advertisers to come even for the first time, okay? And then vertical integration. There's a lot of vertical integration in big tech. It doesn't have to be, it's not by definition. This is Amazon, and this is an example that we're going to come back to as time permits in talking about some ongoing litigation. But basically, it's pretty obvious. This is the platform that Amazon operates, that you and I go to buy, I don't know, breakfast cereal. Amazon is a seller on its platform. Other people are sellers on its platform. Amazon is a competitor against these sellers. It's a supplier to these sellers. Got it? This is all vertical integration is. The question is, if you're a company like Amazon and your customers are your competitors, what do you want to do? Right? If they were just your competitors, you'd want them to go out of business. If they were just your customers, you'd want them to get all the business in the world. But they're both. So the issues around vertical integration in mergers and in ongoing business activities is largely, I think, I'm a lawyer, so I can say this because I could be wrong as a matter of economics, but I think largely around this issue of mixed motives because you're playing more than one role. So you got to decide how you're going to act to try to maximize your profits. Monopoly power. A monopoly is technically a firm that owns 100% of the market. That's not the way we view it in law. That would be too easy. A monopoly is a company that does what it wants. I mean, within limits, but basically does what it wants. It wants to charge you a higher price, say 5 or 10% higher. It can do it, and you don't have any place to go. It goes back to this diagram. You either don't buy it or you pay more for it. But the monopoly is not constrained by competition when it sets its price. This is important because in the United States, at least, a long time has passed with a very big monopoly case between Microsoft and cases that are now pending in court. And so the question comes, people have been saying, more needs to be done about monopoly. And we're going to see in the next couple of years some of these cases play out. And we're going to see the question of how market power and therefore market definition works. Okay. I want to just finish by talking about a couple of areas that you're going to see play out in the next year or so, maybe multiple years. And we're not going to go into detail about all of them, but let me go through, give you a sense. The red are stuff we're going to talk about for a minute, but I just want you to note there are a series of activities that are going on around the world. I've tended to focus on the US, the UK, and Europe, but they are certainly not the only jurisdictions that are involved, and that deal with multiple facets of big tech, okay? I'm just going to give you a couple, just to give you a sense of the Federal Trade Commission in the United States recently launched an inquiry into artificial intelligence and asked about partnerships in artificial intelligence. It's not an investigation, it's not an assertion, but it's an inquiry. And of course, there's a lot of discussion about AI and should it be regulated, and if so, how should it be? I call this one out in particular because we've been talking about mergers and monopolies, but sometimes firms working together can raise issues. In the United Kingdom, the competition authorities have an investigation going of cloud services. And what they're looking at, they say, is whether customers, once they start using one cloud service, can effectively easily switch to another. This is another thing, right? Are you locked in against your will to a particular service? This can be a competition issue. And then in social media, the Federal Trade Commission has a case that was dismissed and reinstated against Meta, against Facebook. And among the allegations in that case are assertions that Facebook, then Facebook, violated the law when it acquired Instagram and WhatsApp. So it illustrates this notion that sometimes we look at mergers before they happen. This is a case that suggests, that argues that Facebook violated the law, but the case is brought after the merger was consummated, and asks for a court to go back and look at the effects of that merger. But I want to talk about the ones in red just for one more minute. Amazon has a couple of cases going, and there's issues affecting it around the world. And I want to talk about a case that was brought in California in 2022, although it's not the only case, but it's one where we have an early decision. So here's how the lawsuit works. The state of California sues under California law and alleges that Amazon takes actions that keeps prices higher than they otherwise would be. Okay? There's Amazon, and then there's its competitor. Let's say Walmart is a competitor. The focus of this case is the allegation that Amazon does things to keep prices higher. Amazon asked to dismiss the case. motion to dismiss, meaning even if everything California said was true, Amazon says it's not illegal, okay, right? And the court denied that, and I want to talk about why. But just so you know, the Federal Trade Commission subsequently filed its own case against Amazon that includes similar allegations and other ones. And Amazon made settlements with Germany, the German Competition Authority, and the European Union. And there's a new segment of the DMA that arguably prohibits what are called price parity clauses, or MFNs, most favored nation clauses. And here's how they work, okay? This is made up, okay, but this is the allegation. Amazon says to, let's say Gene Kimmelman's operating an online store, and let's say somebody wants to buy from it, okay? Amazon saying to Gene, whatever price you charge people using Amazon, you have to charge the same price even if you sell it directly yourself or through another platform. Does that make sense? Okay, same price. So if Gene wants to go to Walmart and say, I'd like to build up a relationship with Walmart, so I'm going to give you a lower price. The California allegation is Amazon says, tough luck. You want to be here on Amazon? In effect, you can't give a lower price to anybody else, okay? This is a controversial issue in the law. And I want to talk about it for a minute because it's pretty fundamental. So I go on my iPhone this morning because Taylor Swift won Album of the Year last night for Midnights on the Grammys. And I decide I want to buy it in vinyl. This color vinyl, apparently. Okay? And this is a mobile phone. So this is pretty much all of the screen, okay, right? Not that much space on a screen. And what comes up is what's called the buy box or the featured products. And the buy box is, if I scroll down more, I would have a chance just to buy it right there for $27.97, 7% off, as it happens from Amazon, okay? There are other people who will sell me this, sell you this, but they don't get the same prominent placement. They don't get featured the way Amazon, in this case, featured itself for the sale of that album, which you gotta say, I probably was not the only one doing this search this morning, right? So what California says is, if Gene is running a music shop competing against Amazon, he must, a third-party seller must agree not to offer lower prices elsewhere, or, for example, they won't appear in this place. And there's industry, and I can't independently tell you what's right, but there's industry commentary that says, because of the way mobile phones work, right? Mobile phones just don't have a lot of space. Being here is very important to being able to sell your products. So does Amazon say to companies, you can't sell lower prices elsewhere, and else you'll lose the chance to be here? The cases are going on, but there's one thing we do know. We know, we did this one before, we know what Amazon is saying, because it's filed a motion to dismiss the Federal Trade Commission action, okay? So these are Amazon's words. The quotes are Amazon's quotes of somebody else, okay? It's worth taking a minute to read this. I'm sorry, I got the wrong one. This is what Amazon says. Amazon does not feature. This is what we mean by the buy box, what we just looked at, and the italics are used in Amazon's own right. It doesn't feature an offer when it knows a customer could obtain the product from a reputable competitor elsewhere for less money. Okay, that's not hypothetical. That's what it says, its practices. And it says, by featuring offers that thinks a customer will like, Amazon reduces the inconvenience and time associated with sorting through many offers. I take this to mean you always get the lowest price on Amazon. And it says, by not featuring offers when it knows the competitor is offering a better price than another store, Amazon builds trust with consumers. Amazon saying it's really important that you always know you can get the lowest price when you go to Amazon. Okay. So the debate, one debate here seems to be, California is saying what Amazon is doing this and prices are higher. And Amazon saying, no, 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 prices are low. This seems inconsistent. You're a third-party seller. You want to sell online through Amazon and Walmart. You'd like to offer a lower price to Walmart, but Amazon objects. Okay? Would you lower your Amazon price so it's the Walmart price, or raise your Walmart price so it's your Amazon price? Views? Anybody got a theory about this one? Somebody here is a third-party seller on Amazon. That's almost true just as a matter of statistics. Anybody have a view as to what you or another third-party seller would do? Yes. You think so? Perfect. That's great. That's great. So this is at the heart of the case, because this is what Amazon says as a group third-party sellers do, just what you say you do. Can I ask what you sell on Amazon? Great, okay. The FTC and the California AG say most sellers do the opposite. They take advantage of the higher price on Amazon. This shows why, if everybody did what you did, Amazon would say prices are lower because they're low on Amazon. If everybody did the opposite, California would say the prices are higher. Yes, no question. Yep.
I'm probably, more than I should share, but we're more or less break even right now on Amazon.
Yep.
I'm not going to be able to sell profitably on Amazon, but I have to sell on Amazon in part because Facebook and Google did such a terrible job with their own stores that let anybody sell, so nobody trusts either store. So whatever social media advertising you do, people see it in Instagram or they see it, where on Google, through a Google search, and then they go to Amazon to buy it,
Okay.
right? But the point there is, raising or lowering prices. I don't know. I mean, it's a small part of the equation, I guess.
It's a piece.
Yeah.
It's for antitrust law. It's an important piece, and so the cases will give us some sense of this. Okay, just before we finish, and if there are other questions, I want to do an advertisement. Wednesday, we're going to have a discussion about one more topic, a detailed conversation about app stores, right? We all use app stores. And we know that globally, Android and Apple constitute, the latest numbers I could find, 99% plus of all operating systems. Apple has only one app store, the Apple. Google is predominantly the Google Play Store. There are actions to try to deal with this, but historically, both have charged commissions. If I'm selling a digital service through an app, I could be charged a commission by as much as 30%. So, Spotify. This is another screen grab. My big achievement for this was that I was able to figure out how to do a screen grab on an iPhone because Gene told me how to do it. I go onto my Spotify free account, okay? I'm thinking of buying a premium service. I get down here, I underlined this, okay? Spotify did not underline this. You can't upgrade to premium in the app. We know it's not ideal, okay? The fight here, and there's litigation, Epic versus Google in the United States, there's Epic versus Apple in the United States, there was a state AG enforcement action in the United States, there's a DMA provision, which is causing a great deal of controversy in Europe right now. The real action here is, are Apple and Google limiting competition by what they do by limiting the app stores? In Apple's case, it's not, it's clear there's only one, and by what they charge. And so what we're going to do on Wednesday is have Nancy, joined by our MIT colleague, Richard Schmalensee, apologies, who represented Apple in the litigation, Epic versus Apple, who defended the App Store policies that Apple imposes, with Nancy, two economists, so you don't have to worry about lawyers doing all the talking again, going into depth on these questions of app stores, how they operate, what to do about them, and what to do about levels of commission. Is 30% too much? Should we do anything about it? Is competition enough to knock that down? These are really important issues, and they're playing out in real time in Europe as Apple has decided what it will do to comply with the new EU law and what has already been attacked by other companies, including Spotify. So hopefully people will have a chance to come by and hear us on Wednesday. Anybody? Yep.
It's a question. Thank you. It's a question of price elasticity, right? So it is an economics question. When you ask me what would I do, I would lower my price because I can't sell as much at a higher price.
Yes.
Right? Apple's essentially, Amazon's essentially making the Chicago school argument for you. We're saying, no, everyone will take advantage of the higher price. Fewer people may buy. Oh, well. I mean, they're proving that they're a monopoly in their argument.
I think they probably wouldn't say it that way, but it's possible. Somebody else? No? Anybody else?
There are a couple of things that I might touch on. One of them, you talked about the Brandeis wanting the regulators. We have a crazy court that wants to take away Chevron deference. Also, distinguishing growth that comes from improved technology that you've invented yourself rather than market power that comes from mergers and that. And, why can you kill the golden the goose that's laying the golden eggs by this? So that also my experience with Amazon is a little different. They do advertise that buy box, and then they have a small saying that may be available at a lower price from other sellers, and they even have a hot link to go to other sellers. So, I mean, the last thing that I think is important is when government wants to force, let's say, a vector to say you must take all comers, and then say Amazon, you're responsible for the quality of the merchandise that this other guy is selling, even though it's on just you're just the intermediary announcement of the sale. That you can be sued for product deficiencies in that, and the same thing with the App Store. If you allow apps, if you allow anyone's app on there, it might ruin phones and that, or steal data. So how can you both hold them responsible for something, but say you have to have a wide open thing? So those are three items that kind of trouble me about this.
Yeah, there is an analogy to one, and then I want the gentleman to. I'm not going to over argue this metaphor because it may be different, but in the history of telecom regulation, there was a time when the AT&T network said you couldn't use somebody else's telephone and connect it to the network because it would bring the network down. And what ended up happening was a set of regulatory standards that the FCC administers to decide on a neutral basis, is there a danger to the network? So that anybody who passed the standard would be able to connect. That was one way of taking into account the trade-off between the need for security, which is legitimate, and the potential of it to be used as a tool against competition. Just one. But Yes, sir.
I had a point like 30%, like it's a digital market. So if any commission is being charged, it should justify the costs. Like what is the commission for? Like if like for pharmaceutical also, if you innovate for 20 years or some amount of years, you have to recover the R&D cost. But what are the, isn't that the question, like what is the fee for?
So this is really an important, this is the heart of what I think is going to get talked about on Wednesday. Let's assume this is what the app stores say. Let's just say it's legitimate. That one of the things they do is they screen against malware. And we want them to, right? I mean, so it's not a debatable proposition that we would like security to be higher. And the app stores say, well, so we have to charge for it. What's happening in Europe now is Apple saying, okay, we'll let other people through, but we have to charge them virtually the same amount of money as the 30%, calculated in different ways, coming out in different ways. So then this question comes up, and a colleague of Tom's at Brookings has written a piece about this. You say to Apple, you got to let other people on so they can compete away the 30%. That's the competition model. But Apple says, to protect security, I got to charge them essentially the same. So there's no particular win. This goes to the gentleman's point as well. What are the European regulators going to do when presented with this? Are they going to do what you've suggested, which is to say, well, we're looking at the costs and they're not, the price isn't justified? Are they going to say, no, we'll find another competition tool so people can come and say, oh, well, we'll just do it for 20%? This has become, in just the last couple of weeks, a very, very important question, which to date, the issues around big tech have not really dealt with, namely pricing of services provided. One way around it is the DMA requires, for example, interoperability and says the gatekeepers can't charge for it, right? But this is different. Tom, last word.
Not necessarily a competitive issue,
Yeah,
as opposed to your point previously
Yeah.
about where do you draw the line between competition policy and sectoral regulation.
that's right.
That this is a regulatory issue more than a competitive issue.
Yes, yes, that's right. And again, bringing to the fore the wisdom of Tom and Jean's proposal for a digital agency to think about these issues. I think people have been very generous with their time. I think we're good for today, John. Am I missing anybody?
We have a few questions from the front row.
Now you're in trouble.
Okay.
This is just for fun. Since you brought up the great Louis Brandeis, um, talk a little bit more about what else he cared about, because he didn't just care about antitrust, right?
Well, he didn't. He cared about two other things that I'm going to talk about. He cared about many other things. One of the things he cared about a lot was judges not imposing their own ideologies. And this was because in 1905, the Supreme Court decided a case abolishing a minimum wage for people who worked in bakeries on the grounds that it impeded the workers' ability to negotiate. Brandeis thought this was ridiculous, that workers did not have the ability to negotiate, and that what the Supreme Court was doing was just taking ideology and making it into law. And a couple of years later, in a case that involved the number of hours a woman could be forced to work at the behest of his clients, I think his sister-in-law, women who were heading an association seeking workers' protections for women, filed what was called the Brandeis Brief, which was 100 pages of fact. Because he thought a judiciary captured by ideology was a danger to democracy, and that he believed that facts were the way to work his way out of it. This was the progressive movement at the beginning of the 20th century. It was the Enlightenment expressed through legal briefing, and I think was at the heart of the way he approached the world.
All right, I want to thank everybody. A couple things real quickly. Thank you, John. I thought that was terrific. You know, before I came back to the Kennedy School, I ran AT&T's international operations. And so this has a little bit of a, I don't know if it's PTSD or exactly what it is. But there are natural questions. I think Tom and Jean and John and Phil Revere were working on a new agency to deal with technology. I think we need to, at some point, at least among us, have a conversation about the question about Chevron deference and what happens if the Supreme Court changes its perspective on that issue. There's a question in here about the dynamic policies around competition as opposed to static perspectives on competition at a point in time, how you take into account innovation and encouragement of innovation in that process. But those are topics that hopefully we'll be able to get to over this semester. And I want to thank everybody for coming. I promise you on Wednesday, we will have more conversation, and perhaps as importantly for many of you, we will have food. So, so enjoy and thanks.